Is the Creole interpreter able to hear me? This is Judge Allen speaking.
Yes, Judge Allen, I hear you.
Good morning. Would you please state your name for the record, Madam Interpreter?
Yes, my name is Michelle Beauvoir.
Thank you very much. We're going to swear you in, and then we'll swear the defendant in. Also, there's a witness. Let me ask, do you need the interpreter, Creole?
Yes.
Okay, so we have, we have an individual who's a witness. I hope you can hear the individual.
Okay,
We'll see.
Okay, I'll let you know if I don't hear properly.
Very well.
Okay.
Please raise your right hand, please.
Levez mes doigts tout.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Est-ce que sermenté ou soit affirmé que témoignage ou pour le bail là, pour la vérité, toute vérité et seulement vérité?
Oui.
You have to answer out
Yes.
loud.
Faut répondre fort, faut parler plus fort.
Oui.
Yes,
Thank you.
Please state your name for the record.
merci. I didn't hear her.
Please state your name for the record.
Okay. Okay, ou ka di non, s'il vous plaît, pour dossier a?
Non, pas monsieur Jean-Renaud César.
Jean-Renaud César.
All right, Mr. Caesar, either the state or defense may have questions of you regarding this case. Please make sure you answer out loud into the microphone so the interpreter can hear you.
OK, so assurez-vous que M. César, que vous pas demander des questions, défendant n'a pas demander des questions, assurez-vous qu'on répond très bien, ou répondre fort et ou parler dans le micro hein, pour interprète là qu'attendez.
Ok, merci un peu.
OK, thank you.
Ms. Fleming?
Good morning, sir. Can you please state your relationship to Miss Pierre?
Monsieur Flem, est-ce qu'on peut dire moi relation avec Madame Pierre, s'il vous plaît? Qui seriez pour lui?
Nous ensemble depuis 2009. Nous passons
We've
Saint-Domingue,
been together.
nous passons Brésil, nous battons 10 pays pour nous arriver là. Journée aujourd'hui, la vie a venu changer, il m'a dit la mort pour moi.
Okay, so I have been with her since 2009. We've been to Santo Domingo together. We've been to Brazil together, and now they're asking for my death.
Are you afraid of Miss Pierre?
Est-ce qu'on peut, Madame Pierre?
Non, nous pas mariés, mais nous ensemble depuis 2009.
No, he didn't understand. He thought that I asked him if he's married to her. May I ask him again?
Yes, please.
Est-ce que ou peut, Madame Pierre?
Est-ce que moi pour elle? Je vais faire une question bien, s'il vous plaît.
Okay, I don't understand the question very well.
Sir, are you afraid that Ms. Pierre might hurt you?
Est-ce qu'on peut que Madame Pierre a fait mal?
Je pense que ça va passer des actes à présenter et ça fait que m'oblige à relayer la police.
Yes, because she's been doing some actions that I had to call the police.
And lastly, do you want to have contact with her while this case is pending?
Et est-ce qu'on voulait gagner contact avec lui toujours pendant que nous dans le tribunal là a fait ça?
Non, dépend de lui-même parce que moi-même après toute mise en passé, il dit me l'a utilisé, il pas besoin d'en vivre encore parce que il travaille et quoi moi l'a utilisé, ça c'est d'après de lui-même. S'il pas veut contact moi, il dit merci.
Okay, it's up to her what she wants. If she doesn't want contact with me, then it really is up to her.
State has no further questions, Your Honor.
All right. At this time, the court does find probable cause for the charge of aggravated battery with a deadly weapon.
Okay? So, kounya nous joignent que gagne cause probable de un attaque qui était faite avec un arme qui est dangereux.
Oui.
I am ordering a bond of $3,500.
OK? M'a demandé que yo paye $3,500 mandat.
I am further ordering that the defendant have no contact with the victim whatsoever.
Et nous dit que défendant pas capable de aucun contact avec victime nan du tout.
The defendant must not return to the location where this incident occurred.
OK, défendant pas capable retourner l'an côté et incident ça a été arrivé.
The defendant is ordered to possess no weapons and no firearms.
Et défendant pas gen droit pour gen aucun zam la kaili, aucun bagage dangereux ou bien aucun bagage qui ka tirer.
The defendant is ordered to surrender all weapons and firearms to law enforcement within 24 hours of release.
Et défendant gen pour bay la police le 24 heures k'ap vini an, tout zam li gen la kaili, tout zam a fait, tout zam qui dangereux.
And the defendant is ordered to comply with any DCF plan that may be entered in this case.
Et défendant gen pour suivre tout ça DCF planifié pour lui, ça qui décidé ici là jodi a.
Your Honor, could you have a one-time return with law enforcement to gather any belongings?
Madam Interpreter, did you?
Yes. Juge, est-ce que l'État capable gen un petit temps pour retourner la Kaili pour aller chercher les affaires personnelles li?
Yes, I will allow a one-time visit in the presence of law enforcement to recover any personal belongings.
Oui, m'a bay li un jour pour aller et prendre toutes les affaires personnelles li, accompagné avec la police pour qu'elle cherche les affaires li la Kaili.
Thank you, ma'am. Thank you, sir.
Merci.
You are
Merci, madame,
excused.
merci, monsieur.
Merci un peu.
Thank you.
Thank you, Madam Interpreter.
My pleasure. And this is it? You don't have...
That's it. Have a good day.
Okay. You do the same. Thank you.
Okay.
Bye-bye. Thanks.
This is Judge Allen. Is the interpreter connected? Hello? Let me try it again.
Good morning, Your Honor. This is Pedro Leon, certified Spanish interpreter. I have been previously sworn.
Good morning. This is Judge Allen. This is Blanca Reyes.
Reyes is currently on mental health status.
Okay, Reyes is on mental health status, so not present. The case will be reset for 24 hours. EUCBO Torres, come to the microphone. As to Eusebio Torres, it's case number 2023 CF 5284AO.
The interpreter can confirm there is connection with the headsets, Your Honor.
All right, very well. Mr. Torres, in your case, I do find probable cause for count 1, obstructing justice or hindering a witness communication. And I am setting a bond of $1,500. I find probable cause for count 2, battery, dating violence, and I set a bond of $500. However, sir, you also do qualify for the pretrial release program. And so I am also ordering that you be released on PTR with the following conditions: that you have no contact with the victim whatsoever, that you possess no weapons and no firearms and surrender all weapons and firearms to law enforcement within 24 hours of release, that you comply with any DCF order that might be entered in this case, that you not return to the location where this incident occurred. Do you understand, sir?
Your Honor, is it
Your Honor.
bond or pretrial release?
Bond and pretrial release.
Your Honor, I would also ask for a one-time return with law enforcement. I believe they resided together.
I will authorize a one-time visit in the presence of law enforcement to recover any personal items. Thank you, sir. The next case is Javier Duran Rivera. This is case number 2023 MM 2753AO.
My apologies, Your Honor. 2023 MM 2738.
No, the last part, 2753.
Thank you, Your Honor.
You're welcome. Mr. Duran Rivera? Yes, sir. The court, I know that there's a witness. Let us have the witness to swear herself in. Go ahead, Madam Clerk.
Do you swear? Raise your right hand.
Raise your right hand to be sworn in, ma'am.
She needs Spanish as well.
Yes, interpreter, Mr. Interpreter, we need you to interpret. There's a witness.
Please raise your right
Very well, at your service, Your Honor.
Okay. Please raise your right hand to be sworn in.
Levante su mano derecha para prestar juramento.
Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth?
Jura o afirma que el testimonio que dará será la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes. Puede bajar la mano.
Please state your name for the record.
Por favor, diga su nombre para que quede sentado en el acta.
Lindy Morales.
Lily Morales.
Ms. Morales, either the state or defense may have questions of you. Please make sure you answer the questions into the microphone. Thank you.
Señorita Morales, ya sea la fiscalía o la defensa tendrá preguntas que hacerle. Si le hacen alguna pregunta, asegúrese de contestar directamente al micrófono. Gracias.
Good morning, ma'am. Can you please state your relationship to Mr. Duran Rivera?
Buenos días, señorita. ¿Me puede decir cuál es la relación que tiene usted con el señor Durán Rivera?
Es mi pareja,
He's my partner,
el papá de mi bebé.
Are you,
the father of my baby.
are you afraid of him?
¿Usted le teme?
No.
No.
Has anything like this ever happened before?
¿Algo como esto ha sucedido anteriormente?
No.
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Si algo como esto o algo más severo ocurriría en el futuro, ¿usted se asegurará de llamar al 911?
Sí.
Yes.
And do you want to have contact with him while this case is pending?
¿Y quiere usted tener contacto con él mientras este caso está pendiente?
Sí.
Yes.
State has no further questions, Your Honor.
¿No más preguntas por parte de la fiscalía?
All right, very well, thank you. Mr. Duran Rivera, I find probable cause for the charge of battery domestic violence.
Ok, muy bien, muchas gracias. Señor Durán Rivera, determino de que existe causa probable ante la acusación de agresión, violencia doméstica.
You qualify for pretrial release, and I'm ordering you to be released on the pretrial release program.
Usted califica para la libertad condicional y le autorizo a que sea liberado bajo el programa de la libertad condicional.
The conditions of your release are that you have no hostile contact with the victim,
Las condiciones para su libertad es que no puede tener ningún tipo de contacto hostil con la víctima.
that you possess no weapons or no firearms,
Tampoco puede tener en su posesión ningún tipo de arma, ni arma de fuego ni blanca.
that you surrender any weapons or firearms in your possession to law enforcement within 24 hours of release,
Y que si usted es propietario de cualquier tipo de arma, usted las tiene que entregar a las autoridades dentro de las 24 horas después de ser liberado.
that you possess and consume no alcoholic beverages,
Le ordeno que no puede tener en su posesión ni puede consumir ninguna bebida alcohólica.
and that you are subject to random alcohol testing while in the pretrial release program.
Y mientras esté bajo libertad condicional, usted se tiene que someter a exámenes sin previo aviso de alcoholemia.
Do you understand, sir?
¿Entiende usted, señor?
Sí.
Yes.
All right, thank you. Thank you, ma'am.
Y gracias a usted, señorita, también.
Wait a minute, sir. Wait a minute.
Perdón, señor, espere.
Ma'am, you have a question?
Señorita, ¿tiene usted alguna pregunta?
Sí, señoría.
Yes, Your Honor.
You may ask.
Puede preguntar.
Ok. Yo quisiera preguntar si es posible.
Continúe, señorita.
Ma'am, you can continue your question.
Puede continuar con su pregunta, señorita.
Si es posible que al señor Javier Durán se le pueda remover todos los cargos. No quisiera levantar ningún cargo contra él.
I would like to ask if it is possible that all the charges against Mr. Javier Duran could be withdrawn. I do not want to file any charges against him.
Ma'am, that is a very good question.
Señorita, esa es muy buena pregunta.
Now that the case has been filed, it will be up to the state attorney whether to drop the charges or not.
Ya que el caso ha sido radicado en el tribunal, depende ahora de la fiscalía si desean retirar las acusaciones o no.
The state attorney's office has a procedure that they must follow to make a decision on whether to pursue or to drop the charge.
La Fiscalía del Estado tiene cierto procedimiento por el cual ellos se tienen que regir cuando toman una determinación si quieren proceder con la acusación o retirar las acusaciones.
The procedure has already begun, and ultimately it is their decision.
El procedimiento ya ha comenzado, por lo que, eventualmente, es la decisión de ellos.
Thank you, ma'am.
Gracias, señora.
Ma'am, I am giving you a card with the state attorney's phone number and the case number, and you can call them and let them know what you need to do.
Señorita, yo le estoy dando una tarjeta en estos momentos con el número telefónico de la Fiscalía. Y usted puede comunicarse a ese teléfono y dejarle saber qué es lo que usted desea hacer.
No more Spanish. Mr. Interpreter, have a good day. That's the last Spanish case.
You have a wonderful morning, Your Honor.
You do the same. David Wood. Mr. Wood, in your case, the court does find probable cause for battery, domestic violence. Counsel?
Yes, for the record, Attorney Jay Ruth, we're just asking for a straight monetary bond of $1,000. The victim is also present and would like to put some statements on the record regarding contact.
All right, let's swear in the victim.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name for the record.
Ashley Roach.
Ms. Roach, you need to speak up a little bit louder.
Ashley Roach.
And good morning, Ms. Roach. Can you please state your relationship to Mr. Wood?
He's my husband.
Are you afraid of him? Has anything like this ever happened before?
Yes.
Okay, wait a minute. I can't hear you, Ms. Roach. I need you to speak up.
Okay. Sorry.
I did not hear the second question, and I did not hear the third question. Well, I heard the questions. I did not hear your responses.
I am not afraid of him, and yes, it has happened before.
Okay.
Since you're also taller, you might have to bend down to the microphone, just so we can hear you.
Okay.
And you stated that something has happened before. How long ago was the last time other than this incident?
Months ago. I don't remember.
If something like this or something more severe ever occurred in the future, would you feel comfortable calling 911?
Yes.
And do you want to have contact with him while this case is pending?
Yes.
Do you believe drugs or alcohol were involved in this incident?
Yes.
Which of the two?
Alcohol.
That's all I have, Your Honor.
All right. Did you want to ask her anything, Mr. Ruth?
Just, did you want him to come back in the home?
Yes.
Okay, nothing further, Judge.
So based on what I have heard, he does qualify for pretrial release, and I'm going to order pretrial release rather than a straight bond. I am ordering these following conditions: have no hostile contact with the victim, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. I am ordering you to consume and possess no alcoholic beverages, and you're subject to random alcohol monitoring while in the pretrial release program. Thank you, sir.
So we can return to the home, correct, Judge?
Yes, no hostile contact. He can return to the home based on the testimony of the victim.
Thank you, Judge.
Thank you. Jakeesh Broomfield? Jakeesh Broomfield? All right, in your case, I do find probable cause for the charge of aggravated battery with a deadly weapon, and bond will be set to $3,500. You are ordered to have no contact with the victim, possess no firearms or no weapons, surrender any firearm or weapon to law enforcement within 24 hours of release, and not return to the location where this incident occurred.
Does she have a one-time return when law?
I'll allow a one-time visit in the presence of law enforcement to recover personal items and effects. Thank you, ma'am.
And Your Honor, DCF was also contacted.
In your case also, ma'am, one final order: you must comply with any DCF order that's entered in this case. Thank you. Christine Dahl. Ms. Dahl, in your case, I find probable cause for aggravated battery with a deadly weapon, and bond will be set to $3,500. You're ordered to have no contact with the victim, not return to the location where this incident occurred. You are also ordered to possess no weapons and no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of release.
And could she also have that one-time return?
I'll allow a one-time visit in the presence of law enforcement to recover any personal belongings or effects, and thank you, ma'am. Antoine Maurice Henderson. Mr. Henderson, the court finds probable cause for 4 counts. Count 1, battery, domestic violence by strangulation. Bond is set at $1,000. Count 2, cruelty toward children or abuse without great bodily harm. Bond is set at $150. Count 3, resisting an officer. Bond is set to $150. And count 4, battery. Bond is set to $500. You are ordered to possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Have no contact with the victims, all victims in this case, not return to the location where this incident occurred. You're also ordered to, was DCF involved in this case? Yes, ma'am. Comply with any DCF order that might be entered in this case. You're ordered to possess no weapons and possess and consume no alcoholic beverages while on bond, and you're subject to random alcohol analysis, which will be done through the pretrial release program while you're out on bond.
You said the kids are gone? Those are the only victims? Your Honor, the children are no longer at the residence. DCF has taken the children. Could he be allowed to return?
I'll allow a one-time visit in the presence of law enforcement to recover any personal items, but no further contact or no remaining at that residence.
So you can't stay there.
Geraldine Jameson.
Your Honor, she's currently on mental health status.
On mental health status. I'm sorry?
Defense will waive.
Okay. The court does find probable cause for count 1 and count 2. Bond is set to $1,000 on count 1, $500 on count 2. No contact, no return, possess no weapons, no firearms, surrender weapons or firearms to law enforcement within 24 hours of release. One-time visit in the presence of law enforcement to recover personal items. Kevin Moreno. In your case, the court finds probable cause for 4 counts. Count 1, resisting an officer. Bond is set to $150. Count 2, larceny. Bond is set to $100. Count 3, battery. Bond is set to $500. And count 4, robbery by setting snatching without a firearm or a weapon, and bond will be set to $1,000. According to your application, you do not qualify for the public defender's office. In your case, I will not appoint the public defender. You are, of course, allowed to retain your own counsel to represent you. Do you understand? I am ordering the following. You are to have no contact with the victim, not return to the location where this incident occurred, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. You raised your hand?
Yes, ma'am. I have no firearms. My car is in the complex of the residence. Will I be escorted there?
You can have a one-time visit in the presence of law enforcement to return to the residence to recover any personal belongings that belong to you.
And I contact them and then get escort?
Law enforcement, yes.
For my residence, I'll call them and have them escort me.
Yes, you call law enforcement. Thank you. You too. Andre Ramos. Mr. Ramos, I think there's a witness. We'll swear in the witness.
I do. I'm sorry? Amy Nightingale.
All right, Ms. Nightingale, I do need you to respond to any questions that may be asked by the state or defense by speaking into the microphone. Thank you.
Good morning, ma'am. Can you please state your relationship to Mr. Ramos?
On and off friends for 6 years.
All right, I'm going to need you to repeat that, and I need to hear what you are saying.
We've been on and off for years. Dating, relationship on and off.
Are you afraid of him?
Yes, terrified.
Do you believe drugs or alcohol were involved in this incident?
I'm sorry?
Do you believe drugs or alcohol were involved?
Absolutely. Drugs, alcohol, absolutely, and I think cocaine.
And do you want to have contact with him while this case?
Never, to the day I die, never again.
And were you guys currently living together?
No, he wants to, but no, that's not happening.
You do have your own residence separate from him?
Yes, he doesn't know where I live.
I did not hear the last thing she said.
That he doesn't know where I live.
Okay.
I just moved.
Ma'am, the location where this incident occurred, what was your connection to that location?
I work for Hilton.
Was this your place of employment?
No, we stayed there for one night to have a good time.
Okay, so the location where this occurred was not, you have no connection to that place?
Not daily, no. I
Okay,
can rent
got
it,
it.
but that's it.
All right. Mr. Ramos, in your case, I find probable cause for all three counts. Count 1, false imprisonment, bond is set at $3,000. Count 2, aggravated assault, bond is set to $500. Count 3, battery, bond is set to $500. You are ordered to have absolutely no contact whatsoever with the victim. You're ordered to maintain a separate residence from the victim. You are ordered to possess no weapons and no firearms and surrender any weapon or firearm to law enforcement within 24 hours of release. You're subject to random urinalysis, including drugs and alcohol testing, and I am ordering you to consume no alcoholic beverages and consume and possess no alcoholic beverages and consume and possess no illegal drugs or narcotics other than what may be prescribed by a doctor. The random urinalysis for drug and alcohol testing shall be done through the pretrial release program, and it shall be at your own expense. Do you understand, sir?
Yes, ma'am.
Ma'am, did you have your hand raised, so go ahead.
Yes, so when he was, he wanted to put the knife through my neck. I didn't.
Go ahead and speak into the microphone.
When he had the knife to my neck, I didn't see no charge for that.
Let me hold the paperwork back. That is the aggravated assault.
Oh, because I would think it would say with a weapon.
Into the microphone, ma'am.
I would think it would say with a weapon.
Well, ma'am, you're not a lawyer. I do appreciate your concern. Aggravated assault involves a weapon.
Okay.
Simple assault does not. I appreciate your concern. Now, listen to me very carefully. if you have continuing concerns about the charges that were filed, they are determined by the state attorney, and you can take your concerns to the state attorney.
All right.
However, this charge is involving a weapon,
Got it.
and I have ordered him to possess no weapons and to surrender all weapons to law enforcement within 24 hours of release.
Thank you.
All right, you're welcome. Anything further?
No.
You're excused. Thank you, sir. James Clark.
Yes, ma'am.
Mr. Clark, in your case, I find probable cause for a battery. And you qualify for pretrial release, so I am ordering you to be released on the pretrial release program. Conditions of pretrial release are as follows: that you have no contact with the victim whatsoever, not return to the location where this incident occurred, maintain a separate residence from the victim, that you possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Marshall Dean.
I believe DCF was contacted on this case as well.
Okay.
Let me see that paperwork back
I believe it says it on the last.
on the last. Hold on a second.
Okay.
All right, I will also order, sir, that you comply with any DCF order that may be entered in this case.
And,
Thank
Your Honor,
you.
could he also have a one-time return with law enforcement to get any belongings? They did reside together.
State any objection to that?
No, Your Honor.
I will allow a one-time visit to the residence in the presence of law enforcement to recover any personal items or effects. Thank you, sir. No, I'm sorry, Marshall Dean. Marshall Dean. In your case, I find probable cause for battery, and you qualify for the pretrial release program, so therefore I am ordering you to be released on pretrial release. The conditions of pretrial release are that you have no contact whatsoever with the victim, do not return to the location where this incident occurred, that you possess no weapons and no firearms, and surrender any weapon or firearm to law enforcement within 24 hours of your release.
And could he have a one-time return?
I'll allow a one-time visit in the presence of law enforcement to recover any personal effects. Thank you, sir. Anaya Jackson. In your case, the court does find probable cause for battery, and I will, so Anaya doesn't qualify for pretrial release?
Her fingerprints didn't clear at the time, but we already qualified her.
She is qualified? Okay. So I will allow you to be released in the pretrial release program. You're ordered to have no contact with the victim. State, do you know if the law enforcement officer made a referral to the state to charge the victim because he said he could not have determined a primary aggressor in this case?
I believe it wouldn't be in our system yet, just due to it being uploaded last night.
The only reason I'm asking is because I really don't know what the living circumstances are. I could order them both to not return to the residence, but somebody may be able to be there. I just don't know who. I don't know if the charges were contemplated against the victim or no charges were I'll just assume that they are just under contemplation at this time. Ma'am, I am going to order that you not return to the location where this incident occurred and that you maintain a separate residence from the victim. You are allowed a one-time visit to recover any personal items from the residence. I am ordering you to possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. All right, thank you. James Johnson. James Johnson. James Johnson, the court finds probable cause for battery, dating violence, and you do qualify for pretrial release. I am ordering you to be released on the pretrial release program. Conditions of pretrial release are that you possess no weapons and no firearms and surrender any weapon or firearm to law enforcement within 24 hours of release, that you have no contact with the victim and not return to the location where this incident occurred. And thank you, sir. Avon Martin. Avon Martin.
We have a one, she doesn't live.
No, she just visit.
Your Honor, he's stating the victim does not reside there. She only visits him, so I would ask that you allow him to return home.
Unfortunately, I don't know that that's confirmed at this time, so.
Your Honor, state's concerned regarding that's the address the victim gave law enforcement is the same address.
I will allow a one-time visit to recover personal items or effects, and until that information is confirmed, my order remains the same. Okay, Avon Martin. In your case, the court finds probable cause for battery, domestic violence, and you do qualify for pretrial release, and I am ordering you to be released on the pretrial release program. Conditions of pretrial release: no contact with the victim, no return to the location this incident occurred. Further, you must possess no weapons or no firearms and surrender all weapons or firearms to law enforcement within 24 hours of release. Frank Mascali. Mr. Mascali? Yes, in your case, I do find probable cause for battery. You qualify for the pretrial release program, and I am ordering you to be released on the pretrial release program with the following conditions: no contact with the victim, no return to the location this incident occurred, possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of your release. And thank you, sir.
And Your Honor, DCF was also contacted on that.
In your case, I am ordering you to comply with any DCF order that may be entered in your case. Thank you. Richard, yes, ma'am?
You gave a one-time return with law enforcement?
I will allow a one-time visit in the presence of law enforcement to recover any personal items or effects. Next case is Richard Mills. Richard Mills. No Richard Mills?
Yes.
Are you Richard Mills? Yes, ma'am. Okay, you're just standing there not saying anything. I need you at the microphone, Mr. Mills. I do find probable cause in your case for the offense of battery. You do qualify for pretrial release, and I am ordering you to be released on the pretrial release program. He does not qualify for the public defender. Madam Public Defender, he makes too much income. So I am not ordering the public defender in this case. Sir, the conditions of pretrial release are that you have no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release, that you have no contact with the victim, not return to the location this incident occurred, but you are allowed a one-time visit in the presence of law enforcement to recover personal items, and that you maintain a separate residence from the victim.
Your Honor?
Yes, ma'am.
Sorry, I also spoke with Mr. Mills' son this morning. He lives out in South Carolina. His son is in the process of having his father move to South Carolina. He's unsure of the date.
Yes.
But it could be, he said, maybe a month or 2 months from now. Can we just have on the court order to reflect that he's able to reside in South Carolina?
Any objection from the state?
If he does go, thank you, Judge.
I will authorize you to reside in, is it South Carolina? In South Carolina, assuming you provide a detailed location, address, and other contact information to pretrial release before relocating to South Carolina. Do you understand? Okay, thank you.
Thank you, Judge.
Nigel Ramos. Mr. Ramos, in your case, the court finds probable cause for simple assault with the intent to or threat to do violence. You do qualify for pretrial release, so I am ordering you to be released on a pretrial release program. I will order that you have no contact with the victim, not return to where this incident occurred, possess no weapons or no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you.
And could he have a one-time return, Your Honor?
Yes, I'll allow a one-time visit in the presence of law enforcement to recover personal items. Thank you. Samuel Taylor. Mr. Taylor, in your case, I find probable cause for battery and domestic violence, and you do qualify for pretrial release. I am ordering you to be released on the pretrial release program. The conditions are that you have no contact with the victim, not return to where this incident occurred, possess no weapons, possess no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you. You can exit. Thank you. Edward Thomas. Sir, in your case, I find probable cause for battery, domestic violence, and I am ordering you to be released on the pretrial release program for which you qualify. Conditions are that you have no contact with the victim, do not return to where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal items, that you possess no weapons, possess no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of your release.
And DCF was also contacted.
I am ordering that you comply with any DCF order that may be entered into this case. Thank you. Michael Young. Mr. Young, the court finds probable cause for battery, domestic violence. There's a witness. We're going to swear the witness in. Ma'am, please speak into the microphone.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Speak into the microphone. Speak into the microphone, please. State your name into the microphone.
Casey Young.
Speak a little bit louder when you answer the questions of either the state or defense who may have questions for you. I need to hear you, ma'am, okay?
Yes, ma'am.
I cannot do anything if I can't hear you, but completely annoy you by asking you over and over again to repeat yourself. So let's just not do that, okay?
Understood, Your Honor.
Good morning, ma'am. Can you please state your relationship to Mr. Young?
Ex-wife.
Are you afraid of him?
Yes, ma'am.
Has anything like this ever happened before?
Yes, in 2015.
Are you willing to call 911 if anything like this or anything more severe ever occurred in the future?
Yes.
Do you believe drugs or alcohol were involved?
Yes, ma'am.
Which of the two?
Alcohol and possibly steroids or testosterone injections.
I cannot hear you, ma'am.
Alcohol and possibly steroid or testosterone injections.
And do you want to have contact with him while this case is pending?
No, ma'am.
And are you guys currently residing together?
No, ma'am.
Thank you. So there's no further questions, Your Honor.
All right, sir, the court finds probable cause for battery, domestic violence. You do qualify for pretrial release, but based on the information I have heard, I am ordering a bond and pretrial release. The bond I'll set at $500. Conditions of bond and pretrial release are that you have no contact whatsoever with the victim, that you not return to the location where this incident occurred, maintain a separate residence from the victim, that you possess no weapons and possess no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release, and that you, I am ordering that you be subject to random alcohol and drug monitoring through pretrial release. So therefore, I'm ordering that you consume no alcoholic beverages and consume no illegal narcotics or drugs unless prescribed by a doctor or medical professional. Right. Thank you.
Your Honor, before we move along.
Somebody said, Your Honor.
I did, Your Honor. Before we move to the next case, can we recall Mr. Taylor Samuel? He was the.
Yes. Go backwards, Madam Clerk, to Taylor Samuel. Did you, wait, one moment. Okay, I got it. Different people look like they're raising their hands. Did you have another question, ma'am?
Yes, ma'am. We have his.
Okay, hold on a minute. We have to get that defendant back in,
Sorry, just.
who we just had,
Michael Young.
the last defendant, and then Taylor Samuel. Mr. Michael Young, we have a question on the table. Ma'am, go ahead and ask your question.
Can we authorize a one-time law enforcement? We do not reside together, but his truck is at my place.
I heard the one asking to authorize a one-time law enforcement, but the last part of that, what did you say?
His vehicle is currently at my house.
Okay, so you need him to come there and pick up his vehicle.
Yes, ma'am. And does the no contact order include children, or is that to be determined?
What state's the state?
Your Honor, the children were not present during the incident, or I believe on the no contact order that Mr. Young signed. If the children are currently with Ms. Young, that would have to be another court hearing, potentially in front of in front of Judge McGinnis.
Okay.
So I believe currently with the no contact order he signed, the children are included.
So ma'am, just out of an abundance of caution, I am ordering no contact with you and no contact with any minor child unless authorized in the future by a judge.
Your Honor, I would object to the no minor children.
That's my order at this time. However, I have no objection to the judge amending that order if additional information is provided to the judge.
No, I understand, Your Honor. I was just saying no, no minor children in general.
Oh, I'm sorry.
Thank you.
The minor children of the victim.
Thank you.
The victim's minor children, sorry. Now, the other thing, yes, ma'am, I will allow a one-time visit to your residence in the presence of law enforcement to recover the car. Are you indicating that that's all that's there, or are there other personal items there?
The personal items have been placed in his vehicle.
All right, sir, the order is only to recover the vehicle. And I guess any keys that might be, you may have to the vehicle.
Yes, ma'am, I can put them in the truck when law enforcement arrives.
Okay, thank you, ma'am. All right, now you have asked me to recall someone. Who was
Yes.
that?
Taylor Samuel.
All right, recalling Samuel Taylor. Is he still here? Yes. And what was the purpose of the recall?
Your Honor, he is actually taking a vacation to Jamaica, and I just wanted it, as long as he provides all his information, the pretrial release, the outgoing flight information, the incoming.
Yeah, that's on,
He gave it to you?
supervision agreement. We have to specify that if he's going out of state, he needs to update that with his supervising officer. So he's given that information.
Okay,
That's already on the supervision agreement.
okay. I just wanted to make sure he'd be allowed to go on that vacation.
It's up to them.
When is the date of the vacation?
I leave Wednesday, 5 in the morning.
This Wednesday?
Yes.
Well, I will authorize any pre-planned vacation to Jamaica as long as the departure and departure to Jamaica and arrival back to Orlando information is provided to pretrial release prior to your departure. Do you understand? What's the time frame for this vacation?
It's a 4-day vacation.
4 days? Not to exceed 4 days.
I should be back Sunday.
Well, as long as you provide the information, I have no objection to it. Pretrial release, if you all have an objection to it for whatever reason, that's your assessment. I, as the judge, I am saying I have no objection to it, but I don't know what you all are gonna find out. If you all look at the ticket and it looks questionable or you have some concerns, use your own judgment. As long as pretrial release believes that everything is in order, then I have no objection to it.
Thank you.
Do you all understand that, pretrial release? I'm not making the decision now. I'm just saying I don't object.
And then just let them know, since you said.
All right, this is Ms. Geraldine Jameson. She earlier was unavailable, but she is available now. And ma'am, your presence was waived, but now that you are able to be present, I'm gonna just repeat what I had ordered earlier. I did find probable cause for aggravated assault with a motor vehicle, and bond is set at $1,000. I also found probable cause for battery and set bond of $500. I am ordering, and I have already ordered it, but I'm just repeating it, that you have no contact with the victim, that you not return to where this incident occurred, that you be allowed a one-time visit with law enforcement if you have any personal belongings there to pick them up, that you possess no weapons and possess no firearms, and that you surrender all weapons and firearms to law enforcement within 24 hours of release. I don't recall whether there was a DCF order. No DCF order is imposed in this case. All right, thank you. I want to call Monet instead of who is next. Mehdi Monet.
That's the Mr.
Mehdi, are you Mehdi Monet? Come to the podium. So you were picked up for violation of your probation.
I turned myself in.
Oh, sorry. You turned yourself in for a violation of your probation for a violation of condition 4 by picking up a new law violation, and bond will stay set at no bond. As to that, I have appointed a public defender to represent you. You're getting some information from the public defender right now, so thank you. Confirmed at no bond, okay. And now we can go ahead and have Stefan Washington come in. Mr. Washington, in your case, you were picked up on a fugitive warrant from Providence, Rhode Island, and we have confirmed a no bond status, so bond will stay set at no bond until you are picked up from Rhode Island, or they order us to release you because they don't want to pick you up. Thank you, sir.
The fugitive team should come see him within the next couple days.
Within 24 hours?
Usually, like by Wednesday, they'll come.
Within 48 hours? Sir, we do have a fugitive unit. Their turnaround period is usually within 24 to 48 hours that they will visit you and give you an update on what Rhode Island is saying, okay?
There's no,
Yes, go ahead. No, you don't press that. I have to hear you. You got to talk into the microphone.
there's nothing that I can state for this.
That you can state?
Yeah.
Yes, yes. However, sir, since I'm not the judge who ordered the warrant, you have to say what you have to say to the judge who ordered the warrant at this time. Now, the background information that you might think you want to provide, hold that until the warrant unit comes and interviews you, because there's nothing that can change until and unless I hear from Rhode Island, okay? And I have heard from Rhode Island, and they have said it's a no bond. Last case of the morning, Mr. Justin Watts. In your case, we have confirmed a fugitive warrant from a place in Texas called Hudspeth.
Yes.
Hudspeth.
It was from like 11 years ago, and
Yes, it does seem to have been many years ago. Let me just tell you what I have here. I have a document. The document is dated very well within the last 3 years, and it shows a bond of $100,000. I have other information that says a bond of $0, which is no bond. I am not sure why I got two different pieces of information. I have no idea why. I have one document that seems to support a $100,000 bond, and then another document that someone wrote no bond. And I don't know if it was an error to write the no bond, but this is what I am going to do. Since the $100,000 bond is a bond, I am going to order that instead of ordering no bond, because it is signed by an official from somewhere in Hudspeth, Texas, and it is stamped and it is sealed. So I assume that this is the correct document. However, sir, I'm telling you all this information to say that if we get some updated information that it's actually no bond, then I may have to change that order. But right now, it is $100,000. And I think that the procedure is that since this is a fugitive pickup, that someone within 24 to 48 hours from our fugitive warrant unit, they will interview you and discuss with you what, of course, they're going to talk to the county in Texas as well and give you some update on what is being said about your pickup status from Texas. All right?
okay. So does that mean that I can start a bond process now?
Yes, I have set a bond of 100,000. I have announced to you that there was a bond in the case of, that I was given, the documentation that I was given that states that it's a $100,000 bond. If you are able to post the $100,000 bond, nothing's gonna stop you from posting that $100,000 bond unless before you post the bond, I get some other information that confirms that it really should be no bond or some other number. But I do have a signed document, and it does seem to indicate, well, it has your name on it. It has the same county, Hudspeth County, Texas. So I am ordering a $100,000 bond.
Thank you.
It's the only information I have, okay?
Okay, understood.
All right, you're excused. Court will stand, oh, sorry. All right, Mr. Watts, I have an update for you. Since you and I spoke this morning, the best information we have does show a bond for $100,000 from that Texas county. We have a procedure in place. It is for your protection because we really don't know what's going to happen. One of the concerns that I have is whether or not you will be able to post the bond from Orange County, and I don't think you can, just based on everything that I have been talking to people about since you and I saw each other this morning. You would probably find it almost impossible to post the bond from here, meaning that you would have to try to post a bond from that county in Texas. Do you understand?
Yes.
So we have a process in place where generally I leave the bond set at no bond. And you get scheduled for a hearing in front of one judge that handles all of our fugitive cases. Now, I could do the hearing. I could set the bond at 100,000 and then I could do the hearing. But the best process is for you to go before the judge who does all of our fugitive hearings. Do you understand?
Yes.
And that's Judge Calderon. He and I had a good little conversation this morning because I usually do not get any paperwork that shows a bond amount. I wanted to follow that paperwork, and we do believe it's correct. But once I set that bond at $100,000, number one, you probably can't post it, not from Orange County. And number two, I have to set the hearing. That means you got to come and see me. And I don't handle these kind of cases normally, which isn't impossible for me to handle it. I could do it. But I prefer for your benefit that you do the same process that everybody does so that you don't get lost in the system or something gets overlooked. Now, so I'm saying all that to say to you that this morning when I told you that I might have to reset this to zero bond, well, that's what I think I should do. Do you understand?
I do understand. Is there a way we might be able to do ROI? I live in Texas.
When you say ROI, what do you mean?
Just basically release on my own incognizance for me to actually go to the courts.
So we call that ROR.
ROR, okay. Yeah.
But I understand what you're asking. So several things are going to be happening kind of at the same time. One is that the fugitive unit is going to be contacting that county in Texas and determining what their thoughts are. Do they want the bond of $100,000? Do they want us to start the extradition proceedings? And then do you want to just go to Texas and not have and waive extradition? And at the same time, Judge Calderon, if I set the no bond, is going to set you on his normally scheduled hearings, which he told me he usually does on Wednesdays. I don't think he would have you this Wednesday, though. It would be next Wednesday, more than likely. I really don't know. It's just that he does them on Wednesdays. Me, I don't usually do these hearings at all. But if I'm the one who sets the bond, then I'm the one who's doing the hearing. So I don't want you to fall through a crack in the system, because that can happen. Generally, I am very, very careful not to let anyone fall through a crack if they have a case in front of me. But since we do have this great system in place to make sure that there's one judge that talks to our fugitive unit, that's Judge Calderon. Now, I did talk to the fugitive unit this morning. We had a really good conversation. So I think you'll be protected either way. But I wanted you to know that the information I gave you this morning, that, do you remember I told you that I may have to reconsider and actually set the no bond? Do you remember I told you that? I think it's in your best interest not to have to come to me for the hearing. It's just the way that our administrative order is that whoever the judge is who sets you a bond, that's the judge who follows up on the hearings. And so we have a volunteer judge who is just, a really nice judge who understands that these are kind of different issues and we don't want people falling through the cracks. So we try to let you all go to the same judge, right? Every fugitive case go to the same judge. And I'm only explaining this to you because this morning when I saw the paperwork, I did not want to set no bond when I knew there was a $100,000 bond from Texas, and it still is $100,000. So, but being that you are a fugitive, I really don't know what to do other than to set the bond at no bond to make sure you get to go through Judge Calderon's regularly scheduled procedures and to protect you from being stuck in Orange County Jail trying to post a bond that no bondsman might feel comfortable posting because it's so far away. And then I don't know how, you could contact the other people from the other side. You have a question? Go ahead.
Yes, I do. My situation is just a little bit different. I was actually taking a business trip when this happened. We had a business convention that was actually taking place in Punta Cana in Dominican Republic. It was an award ceremony. My kids are dropped off with a babysitter temporarily in Las Vegas. I live in Texas, and it's just like, I'm like, my hands are tied. I don't even really know what to do. I have.
Can you afford to hire an attorney?
I mean, I only could from the outside. I have no access to my funds. I run a business in Houston, so I have no choice but to be in Houston. And my payroll is supposed to be processed last night, which means that my employees aren't going to get paid, and I'm going to wind up in some other legal issues there.
Right.
Yeah, I'm the sole provider for the company, as well as my children. So I'm just trying to see if there's a way I can do an ROR. If I can get a date, a number, somebody that I can contact in Hudspeth County, I'd be happy to follow up with the process and even post bond to them, even when I get out there.
Two things. Based on what you are saying, then your best, we have the fugitive unit. They are going to be contacting Texas. They always do. That's what they do. That's their job. Now, the one thing I did not ask the fugitive unit is whether they would contact Texas if I set the bond, if I keep it at 100,000, because now you would have a bond and maybe they would feel like, well, since you have a bond, they no longer need to contact. I guess I would have to have them up here to ask. I cannot contact the Texas, and I don't plan on doing it. But we do have the fugitive unit, and that is part of what they do is they contact the other county and state and determine what their intentions are towards your case. But you just kind of made me figure out that I do now have another question, and that is that given that I did order the bond, does that stop them from, because now that they see you have a bond, does that mean they will not contact and give you any updated information as to what Texas is saying? But that is what their job is. That's what they are here for. So I guess I need someone from the fugitive unit. Can I get someone from the fugitive unit here in the courtroom? I'll have to pass your case and check with the fugitive unit. And then if they say that they'll still work on it and try to get as much information as possible, then I may just leave the $100,000 so you can try to bond out. But I mean, I don't know how you can though. It is, from Judge Calderon, who I spoke with this morning, who's I'm just gonna call him an expert since he always handles these kind of cases. He has never heard of anyone being able to do it. And that made me concerned about you. Thinking that you could try to bond out and then not being able to do so, and that it might be in your best interest to just let the process play out the way that it normally plays out. But at the same time, I would be happy to leave that $100,000 if that was the best course of action. I just think the other way is better. However, I am going to ask the fugitive unit what they will do on your case if you do have a bond. Usually there's no bond. Nobody gets any paperwork and shows it to me for fugitive cases. Most fugitive cases have no bond. Your case is slightly unusual, and so.
Yeah, it's very unusual.
Yeah, well, most times, if I order a bond on somebody that's a fugitive, I'm gonna do no bond because they're a fugitive, because they're not coming to court. And so it's kind of just an odd set of circumstances where you actually do have a bond, but our procedures mean that uh, any judge who sets your bond, and I don't really know if I'm setting it, I'm just following what the judge from Texas said, or I don't know who said it. I just know that the clerk's paperwork shows that the bond is $100,000. So, in an abundance of caution, I wanted to explain everything to you so that you would not know why a change is being made. But I haven't made the change yet. I am going to first talk to the fugitive unit, so I'm gonna have to pass your case just for a few more minutes. I have so many cases I need to get going, but I'm gonna bring you back in a few more minutes after I talk with someone from the fugitive unit. I just really don't want you not knowing what is going on. To the best of my ability, I am trying to inform you so that you will have all the information that I have available so that you know what's going on. But I cannot help you with some of the questions that you're asking. However, I can find out whether the fugitive unit cancels all contact with Texas once a bond is set, because they think that maybe that answers the question of bond issues. And then you just have so much other things going on here that I cannot answer those questions regarding your kids and your job and how you can get out and all that. I'm sorry, but I can't give you direction and guidance on that. I would just ask again that if there was a way for you to hire an attorney, then maybe you try to consider doing that. Or maybe have someone from your staff, see if they can get an attorney involved on that end in Texas. But in the next few minutes or so, hopefully someone who I talked with earlier this morning from the fugitive unit will come, and me and that person can have a additional conversation, and then I'll bring you back in and I'll make a final decision whether I'm gonna leave it at $100,000 or set no bond and then have you set automatically for a hearing in front of Judge Calderon, because that's an automatic set, okay? All right, thank you. Don't let him go back to wherever he is housed, because I might call him back in a few minutes. All right. Spanish? Okay. Okay. The Spanish interpreter? I can talk to him on the phone. Ask her if she can call in. It's just a simple question. I can talk to her on the phone. No, personal phone call. Yeah, tell her to call in. Should I go ahead on and do the interpreter case while you're doing it? Okay.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter, and I have been previously sworn.
Good afternoon. This defendant is Kelman Ronaldo Lopez Ramirez. His case number is 2023 CT 653 AW.
Thank you, Your Honor. If you allow me just a moment to confirm connection to the headphones, please.
Sure.
Your Honor, the interpreter can confirm that this defendant is able to hear through the headsets.
All right, Mr. Lopez Ramirez, in your case, I do find probable cause for the offense of driving under the influence I am ordering a bond of $500 along with condition that you not drive without a valid driver's license and that you possess and consume no alcoholic beverages. I am ordering you to be subject to a gram alcohol monitoring at your own expense. And I am ordering that before you are released on bond, that it be confirmed that you have activated your agreement with a scram provider. I am revoking the bond on your pending case 2022 CT 1075 AW, and I am ordering no bond. I am appointing the public defender to represent you on the new case. You have a lawyer already apparently representing you on the older case. Do you understand, sir?
Sí.
Yes.
Thank you. Alexis Acosta Molina. Mr. Interpreter, this is case number 2023 CF 5244AO.
Thank you, Your Honor.
Mr. Acosta Molina, I do find probable cause in your case for count 1, possession of alprazolam. Bond will stay at $1,000, and count 2, prohibited activities in a park or recreational facility, and bond will stay at $250. You are ordered to not return to the park as a condition of bond. And I am taking no action on your out on bond case. You have 2 out on bond cases, and I am taking no action on either one of them. He has another case on an out on bond status? What was that charge? It's the second one? Okay. All right. No action on either of those two cases. Thank you. Angel, thank you, sir. Oh, wait, so one final thing. I am appointing the public defender to represent you in your case. And do you understand everything, sir?
Not very well.
Do you have trouble hearing, or do you have trouble understanding the language?
I can't hear.
Maybe we need to fit him with a hearing assisted device. Do you have trouble hearing? Sir, do you wear a hearing aid?
I can't hear very well here.
Okay, is there a way to turn the volume up on that? Or, no, you know what, let's just, Mr. Interpreter, I'm just gonna see if we can do better with it, just coming in our overhead.
Certainly, Your Honor.
Okay, Mr. Mr. Acosta,
Señora Acosta,
I find probable cause for count 1, possession of alprazolam,
determino que existen indicios razonables en el primer cargo de poseer alprazolam
and count 2, prohibited activities in a park or recreational facility.
o actividades prohibidas en un parque o lugar recreacional.
Do you understand that what's been said so far?
¿Usted me está entendiendo? Yes.
I am setting a bond of 1,000 on count 1 and 250 on count 2.
Le programo una fianza de $1,000 en el primer cargo, $250 en el segundo cargo.
And I am ordering that you not return to the park where this incident occurred as a condition of your release.
Como condición de su libertad, no se le permite regresar al lugar de los acontecimientos.
I am taking no action on your two traffic-related offenses that you're out on bond on.
No voy a tomar ninguna acción perjudicial en contra de los casos en la cual usted se encuentra en libertad bajo fianza en este momento.
Do you understand everything now?
¿Me entendió ahora? Yes.
And lastly, I am appointing the public defender to represent you on this new case.
Y por último, le voy a designar las oficinas al defensor público para que lo representen a usted en este caso.
Thank you, sir.
Muchísimas gracias.
You may exit.
Puede salir, caballero.
If you have a question, just ask it into the microphone so the interpreter can hear you.
Caballero, si usted tiene alguna pregunta, por favor, acérquese al micrófono para que el intérprete le pueda escuchar.
Gracias. Me van a dejar ir, ¿qué va a pasar?
So, am I getting out? What's going on?
I said bonds, and you are eligible to post those bonds with the bondsman.
Le programé una fianza y usted tiene derecho a pagar la fianza mediante un fiador.
Ok, gracias.
Okay, thank you.
Thank you, too.
¿A usted?
Angel Cabray, case number 2023 CF 5294AO. And he is being fitted with the headphones right now.
One of the interpreter can confirm defendant is able to hear through the headsets.
Mr. Cabray, the court finds probable cause for count 1, trafficking in fentanyl, and bond will stay at $200,000. And count 2, possession of fentanyl with intent to sell or deliver, bond will stay at $15,000. You're ordered to possess and consume no illegal substances or narcotics or any illegal drugs that are not prescribed by a doctor as a condition of your release. And I am appointing the public defender to represent you in your case. 200,000 on count 1, 15,000 on count 2. The bond stays. These amounts are state amounts.
Can I ask you a question?
Yes, you may, with the permission of your lawyer who's standing there beside you, if your lawyer wants you to ask it.
Could you please advise the client that I would recommend he not go into the facts of the case today? That any defenses he has to what's written.
So if you could just direct him in the first person, and I will interpret whatever you're saying, counsel.
Any of the facts in the affidavit that you disagree with, I would wait until you get one-on-one with your attorney to go over that, as everything is being recorded today.
I know.
I've provided the telephone.
I wasn't given any Miranda rights.
Let me just go ahead and interject here. I'd like to interject. Sir, today's hearing is an initial appearance for me to advise you of what your charge is and advise you of the bonds that are set based on your charges. A hearing, listen please, a hearing regarding any disputes that you may have, such as motions to suppress or motions to dismiss, must be scheduled with the judge where the case is assigned, and only after communicating with your lawyer. Now, your lawyer is the public defender, as I have appointed the public defender. Of course, if you want to hire your own attorney, you may do that as well. All right, thank you, sir.
No me pueden bajar la fianza tampoco.
You're not going to lower the bond either?
Thank you, sir. I said a bond. No, I did. I said a bond, sir, in your case.
Caballero, yo le programé a usted una fianza ya en su caso.
To remind you, the bond is 200,000 on count 1 and 15,000 on count 2.
Para recordarle, el primer cargo son 200,000 de fianza, el segundo 15,000 de fianza.
Pero yo le digo que si no lo pueden bajar.
Thank you,
I'm
sir.
asking if you can't lower that.
No, sir.
No, señor.
Josue Eduardo Ruiz Gomez. We need you to put on the headphones. Mr. Interpreter, this is case number 2021 CF 8164AO.
Thank you, Your Honor. If you allow me just 1 second to confirm headphones.
Yes, sir.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Right, Mr. Ruiz Gomez, you were picked up for failure to appear on 2 counts, and bond will stay set at no bond on both counts. I am appointing the public defender to represent you, sir. Yeltsin Pineda, case number 2023 CT 2726AO. Mr. Pineda.
I can confirm the defendant is able to hear.
Very well. Mr. Pineda, the court does find probable cause for DUI, driving under the influence, and I am setting a bond of $500. I am ordering you to possess and consume no alcoholic beverages as a condition of your bond. I am ordering you to, I'm ordering a scram monitoring device to monitor for alcohol consumption as a condition of bond, and ordering you to, ordering that you not be released until it is confirmed that you have selected a provider for the alcohol monitoring. I also am not appointing the public defender in this case due to income. Well, actually, since I'm ordering the scram, I'm gonna go ahead and appoint the public defender's office, and just in case he is unable to communicate with someone from the scram providing agencies. I am appointing the public defender, however, it may be assessed in the future that you do not qualify for the services of the public defender. Do you understand?
Can you repeat that?
Yes, since I am ordering a scram for alcohol monitoring, it's a device that you have to wear to let the judge know if you are violating a court order to consume and possess no alcohol while you're out on bond. And then if you wear that device and you consume or possess alcohol, the judge would be notified. But technically, you don't qualify for the public defender because of your income. However, because I'm ordering you to get that device, and I don't know what's going to happen if you have some trouble getting that device, then I am appointing the public defender on your case. However, in looking at your application for the PD, it may be revisited by the judge in the future, and you may not qualify, so you may have to hire your own attorney in the future. Do you understand now?
Yes.
You also have one other case. It is a case that you're out on the bond of $1,000, and I am taking no action on that case at this time. Thank you, sir. I'm sorry, you have a question? So with the permission of your counsel will let me know if they want me to answer any question or if they want you to ask it in the first place.
If it is a question about the facts of the case, I would ask that you wait until you get one-on-one with the attorney to go over any defenses you may have. However, if it's a question about the release conditions, you can ask.
So, mi pregunta es, pues, que si yo es posible que yo me pueda ir hoy.
So my question is there a possibility that I can get out today?
He's not.
Well, it will depend on several factors. One of the factors being that I have ordered a secure alcohol monitoring, and you will need to pay for that service. And so you will need to sign a contract with a providing company for that service. And I don't know how quickly that can occur. Then the other factor is the bond that I set, which would need to be posted as well. But once both are complied with, and if it could be all done in one day, then I assume yes. But if it's a delay in taking care of getting the secure alcohol monitoring company, we call it SCRAM. That's the acronym that is used, SCRAM. Then it may not be today. It may be whenever you are able to have that contract signed. And that is the reason why I appointed the public defender, because I cannot foresee in the future whether you can get that done or not. So the public defender will be your lawyer if necessary. Thank you. Andre Luis Ferreira. Oh, sorry. We're at a different language now, Mr. Interpreter. We're on the Portuguese, and I don't think we have any more Spanish.
Thank you, Your Honor. You have a very nice afternoon.
All right. Thank you. You do the same. Bye-bye. Okay. Portuguese. Good afternoon. This is Judge Allen. Do I have the Portuguese interpreter on the line?
Yes, good afternoon, Your Honor. This is Rosa. My ID number is 391057. I'll be your Portuguese interpreter.
Thank you. I appreciate that information. We do have the defendant present. And have you been sworn in, Madam Interpreter?
Not yet today, no.
All right, let's swear her in.
Please raise your right hand. Do you swear to translate from Portuguese to English, English to Portuguese, testimonies given?
I do.
Thank you very much, ma'am. All right, this is Mr. Andre Ferreira Bloodworth?
Yes, it's my name.
All right. Mr. Bloodworth, you need an interpreter for Portuguese?
Yes, I need to interpret for Portuguese.
Okay, Miss Interpreter, can you hear the defendant as he responds, or should I make him get a little closer to the microphone?
Yeah.
Okay.
Yes, if he could come closer, that would be lovely. Thank you.
So I need you to speak into the microphone. Tell him that, Miss Interpreter.
Ok. Olá, eu serei o seu intérprete português para hoje. É preciso que o senhor fale mais perto do microfone, porque o som está baixo.
Ok, vou tentar fazer o máximo possível.
Okay, I'll do my best.
All right, thank you.
Much better.
I find probable cause for your charge of trespass on property after a warning.
Eu estou a encontrar causa provável de entrar para sítio sem autorização depois de receber aviso.
And bond will be reduced to $250.
A fiança vai ser reduzida para $250.
I am appointing the public defender to represent you in your case.
Eu estou a apontar o procurador público para representar o seu caso.
Do you understand everything that's been said, sir?
Eu preciso...
Você entendeu tudo o que foi dito?
Eu preciso relatar o fato ocorrido, que não foi bem isso que aconteceu.
I needed to relay the fact that that's not exactly what happened.
That's okay, sir. I do not need you to go into the facts of the case at this time. Given the fact that I have appointed a lawyer to represent you, I strongly urge you to communicate with the attorney about what you believe actually happened.
Tá tudo ok. Eu não preciso que o senhor vai falando dos pormenores do caso. Como eu apontei um advogado para o seu caso, eu vou encorajar o senhor fortemente para entrar em contato com o advogado e falar acerca do que é que você acha que aconteceu.
I did provide a phone number that I circled where he can call the attorney to go over any issues.
Eu forneci aqui o número que eu circulei, onde você pode ligar para o procurador para falar acerca de qualquer assunto.
Thank you, sir.
Mas, is possible one more time for talk for you, please?
Sir, you need to speak Portuguese so the interpreter can interpret.
Eu queria implorar por falar o que eu estou passando com os policiais que estão incomodando a vida minha e do meu ex-marido por conta de uma cantora famosa que quer colocar o filho na escola. Eu não estou cometendo crime. Eu preciso voltar para o meu trabalho e continuar ganhando meu salário. Eu não tenho família nos Estados Unidos.
Só um momento, perdão. Peço desculpa, então. Deixa o intérprete passar a primeira parte, senão vai começar a ser muita informação, ok?
Ok.
Obrigada. Sorry, the interpreter was cutting him off, or it's going to start to become way too much information. So I really wanted to implore you that I could talk about you with what's going on with the police, because they are really they are really getting in the way of me being able to live my life and my ex-husband. This is about an issue with a singer and them wanting to be able to put their child in school, but I need to go back to school. I need to be able to go get my salary. A moment. Okay? Você precisa de continuar a ganhar o seu salário?
Sim, isso aconteceu há 2 anos atrás. Eu estava trabalhando na FedEx e a FedEx me relatou o fato. Os 2 policiais brasileiros estão trabalhando para a cantora Sandy Leal Lima, do Brasil. Ela está regressando para os Estados Unidos para colocar o filho na escola. E os policiais estão aceitando corrupção e deportando gays brasileiros da cidade de Orlando para que o filho dela não possa sair na televisão ou internet.
Só um momento.
Ok.
Desculpa. O senhor tem que falar só uma frase ou 2 de cada vez, senão começa a ser muita informação.
Vou tentar repetir.
Okay?
Eu tenho 2 policiais.
Não é preciso. Não é preciso, mas deixe-me só passar mas para a frente.
Okay.
Right, the interpreter was cutting off, asking him just to do like a couple sentences at a time, otherwise we have to keep interrupting him.
So I'm going to interject right now. I will not be able to hear any more of your concerns about the facts of the case or the police. I don't know what word you use, but in some sense, I believe you think the police are harassing you and your ex-boyfriend or ex-husband.
Husband.
I am not in a position to make any determinations on police conduct relative to this case. That is something you must discuss with your lawyer.
Então, eu não vou poder ouvir mais nada em relação às suas preocupações com os factos do caso ou com a polícia. Eu acho que entendi que você acha que, não tenho a certeza que é a palavra para usar, mas que você acha que os polícias estão a perseguir você e o seu ex-namorado, ok?
You may exit.
A posição.
Thank you, sir.
Just one moment, Your Honor.
Bye-bye.
Thank you, Madam Interpreter.
It's my second job,
Thank you, Madam Interpreter.
You're very welcome. Thank you for using our services, Your Honor.
It's my
Have a
pleasure.
good day. Bye.
Call him later. Okay. David Clark Rosen? Yes. I don't really know whether or not I did this like I always do. Would the state announce your presence for the record? Defense announce your presence for the record? And I am appointing the public defender on all cases unless otherwise noted. And then we have these 2 private attorneys and maybe 3, because I saw another guy come in. And I don't know if you all discussed with the clerk whether or not we would take your cases out of order or not. If you did not discuss it with the clerk, then your case will not be taken out of order. It will be taken as it comes. All right.
And we did, Your Honor.
We did put our
Okay.
appearance on record at the beginning.
And did I inform you that I'm appointing the public defender on all cases? Let me do that. I'll clarify. I am appointing the public defender on all cases unless otherwise noted. And then, and unless the clerk tells me that the private's already discussed and we took their cases out of order, then they are not taken out of order. Okay, all
There
right.
is an offer on this case.
There's just a lot of moving parts here. There's a lot. I don't even know how I do it, but I do. It's a lot. An offer?
Yes, Your Honor.
Yes.
On Mr. Clark Rosen, state did convey an offer of an adjudication of guilt, credit for 2 days, and no return to the link station at 455 North Garland.
And he would like to accept and answer plea of no contest, Your Honor.
All right, very well. Mr. Clark Rosen, is this your signature here at the bottom of this plea form?
Yes.
Did you read the plea form in its entirety before you signed it?
Yes.
Are you under the influence of any alcohol, medication, or drugs this afternoon? Do you understand that a conviction on your case will subject you to being deported if you're not a U.S. citizen? All right, sir, I've reviewed your file. There's a sufficient factual basis to accept your plea, and you are alert, you are intelligent, you're adjudicated guilty and sentenced to 2 days in jail. You're given credit for 2 days' time served. You're ordered to not return to 455 North Garland Avenue
Yes.
as a result of your plea. I am also ordering all mandatory court costs which must be paid within 365 days of your release. Do you have any questions? Yes or no? You have the right to appeal the sentence. If you wish to appeal, then you must do so in writing within 30 days of today's date. Thank you, sir. You may exit for your paperwork. Query cause? Yes, I appointed the public defender. Mr. Cause, is he accepting the state's offer?
State did convey an offer to Mr. Gauze
Mr. Gauze, sorry.
of an adjudication, credit for time served of 2 days, and no return to the Publix at 2873 South Orange Avenue.
And
All
he
right.
would like to accept and answer plea of no contest.
All right, Mr. Gauze, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read this plea form, sir, in its entirety before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol, medication, or drugs this afternoon?
No, ma'am.
Do you understand that a conviction on your case will subject you to being deported if you are not a United States citizen?
Yes, ma'am.
All right, there is a sufficient factual basis in your case, and I find that you are alert, you are intelligent, you are adjudicated guilty. How much time served on him?
2 days.
You're ordered to serve 2 days with credit for 2 days' time served. And I am ordering your release as to this charge, also ordering release as to the last gentleman as well. Further, I'm ordering you to not return to 2873 South Orange Avenue as a result of your plea. And I am ordering all mandatory court costs to be paid within 365 days of your release from incarceration. Do you have any questions?
No, ma'am.
Yes or no?
No, ma'am, I have no
Right,
question.
you have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. I don't know what happened on the disorderly conduct. Was it part of the plea or?
The plea was asked to both, Your Honor.
Oh, okay, so I also am accepting defense counsel, you concur, was the concurrent 2 days as to the DC, disorderly conduct?
Yes, Your Honor.
All right, sir. Also do find probable cause for the disorderly conduct charge, and I sentence you to 2 days with credit for 2 days' time served. And I, yes, I will order court costs on this, no other sanctions as to the disorderly conduct. Monies again to be paid within 365 of your release. Thank you.
You.
Stephan Anderson.
Good afternoon, Your Honor. Joseph Flynn on behalf of Stephan Anderson.
Good afternoon. Mr. Anderson has 2 counts. First count, lewd or lascivious behavior and molestation of a victim less than 12 years of age by an offender 18 years of age or older, to which I have found probable cause, and count 2, cruelty towards a child by directing or promoting sexual performance by a child, to which I have also found probable cause. What says the defense? He also, just so you know, he has a case that he is out on bond on with multiple counts, in which I was going to ask the state for a recommendation on that. And I don't know if you and the state have already discussed that or not. But, so there's a lot of moving parts here. But let's start with, did you have anything to say regarding the bonds on count 1 and count 2 of the new case?
No, I spoke with the detective. Those were the amounts that she had requested and received from me. Judge to sign the warrant. As far as
Yes, indeed. So I'll go ahead and announce that right now. State, unless you had any input on that, I'm going to just stay with the bond set by the judge.
Your Honor, just for the record, count 1 is a PBL.
Mhm.
So Mr. is not entitled to a bond on count 1. I understand another judge,
Do you object to me setting the bond of $50,000, and are you requesting me to set the PBL amount? No bond?
Your Honor, state is requesting that at this time. However, it's within your discretion whether or not.
Judge Alvaro made a decision to set a $50,000 bond. If the state has indicated that this is a first-degree punishable by life imprisonment, I have no qualms about ordering no bond on this. And so that is what I'm going to do, is the state is requesting it.
Your Honor, may we approach? There's specific reasons for that bond being set that go beyond this courtroom and are.
Do they have anything to do with this other case that I was about to ask the state about?
The other case, Your Honor, happened contemporaneously with this. We knew these charges were coming.
And that is exactly what I was going to ask the state. If all of this was a part of the same process, to which I would take no action on the out-on bonds, or was the state taking the position that it's different and somewhat unconnected, and would be asking me to revoke the out-on bond? And I just needed some insight from the state on that. I still don't see what would change if this is a first-degree PBL. It could have been just an error. The judge wasn't aware it was a first-degree PBL, but of course, I will let you approach if you know something.
Yes, I do. It's pretty prevalent.
Yes, then
Your Honor,
of
state was
course.
requesting no action on the out-on bond.
All right, I won't take any action on the out-on bond. That's settled. Now, would you all approach Mr. Gosh, you know I want to call you Trey. I can't call you Trey. Mr. Flynn wanted to approach. Hold on. After the reviewing additional information provided by both defense and the state, the court still is ordering no bond on count 1, and bond will stay at $5,000 on count 2. The court is ordering that the defendant have no contact whatsoever with any minor child under the age of 18, and that the defendant comply with any previous orders relating to, state, you said there was an order relating to use of the internet, or was that you?
That was me, Your Honor.
Oh, okay.
He has a no use of internet order.
Okay, I'll just do my own no use of internet order. Order that you not use internet services, including apps and social media, as a condition of bond. That you have no contact with the mother of the victim, and of course, no contact with the victim who is a minor. State, are you asking for any other conditions?
No, Your Honor.
All right. I am taking no action on the out-on bond case, since those cases are closely related and maybe even have overlapped in time. So no action on the out-on bond case. The court does recognize that this is different than what Judge Alvaro had written, but this is a first-degree punishable by life, and the court feels that, based on the information that I am aware of, that that is the appropriate bond. Thank you. Thank you, Mr. Flynn.
Thank you, Your Honor.
Yes, ma'am. Did. Yeah. Jareen Clayton. your case, the court does find probable cause on all 4 counts. Count 1, possession of 3,4-methylene, MDMA, ecstasy, bond stays at $1,000. Count 2, possession of paraphernalia, bond is set to $150. Count 3, resisting an officer without violence, bond is set to $150. And count 4, introduction of or possession of a contraband in a county detention facility, bond is set to $500. And, oh, thank you, ma'am. That's it. Thank you, ma'am. Nothing further.
I see what you're saying, that's your defense, that's dealt with downtown. You're gonna have to speak to the attorney assigned right here. You could call.
This the only one?
Defenses you may have.
The only arraignment?
That's not dealt with today.
Oh, yeah.
Set bond. You just- That's it. I'll let them know that you can't pay it. We have a bond
Yeah,
program that pays.
but he's in the next step, like
I'll
here.
let the attorney know.
Should be up here. Okay. These should be before the arraignment, okay. Brian Soto?
Good afternoon, Judge.
Good afternoon. Mr. Soto, in your case, the court does find probable cause for driving while under the influence, and counsel before the court orders bond conditions and what have you. I will hear from you, but I also wanted to advise you that the defendant does have an out on bond matter, that the court was considering revoking the bond with the input from the state. I needed to have the state to provide the court with any background regarding that case before I made a final decision on it.
Judge Michael Brown on behalf of the defendant. If the court is considering revoking the bond and the felony, I would challenge probable cause as to the DUI at this time.
I am considering revoking the bond and the felony. I did want to hear from the state first, though, with regard to revocation of the bond, if the state is requesting me to revoke the bond, or if there's a reason why I should not revoke the bond, if the case has not been filed on, or it seems like due to the age of the case, there is no concern or issue with it being filed on, but I don't know. So I wanted to just confirm with the state first before I made a final decision on that. Let me get input from the state.
Yes, Your Honor, it has been filed on. We did file a possession of fentanyl.
Okay.
I believe is what the alleged substance came back as. And just for some background for the court, in that case, the defendant was allegedly going 25 in a 35-mile-per-hour zone. Law enforcement smelled cannabis and thought he saw cannabis and cocaine in plain view. When searching the vehicle, found drugs. FDLE came back with fentanyl. That's kind of his out on bond factual history or synopsis of his case. State's main concern is the DUI alleged within this incident is also allegedly a drug DUI. It's not an alcohol-related DUI.
Yes.
However, that out on bond possession case occurred in October of 2022. So there has been some amount of time in between. But Mr. Soto does appear to have other drug-related history.
Yes, ma'am.
The state is slightly concerned regarding safety of the community when both of these cases are driving-related and drugs were found both times.
All right. Given the information that I have heard, the court absolutely would be revoking that bond, and I would be ordering, is the state recommending no bond or an increased bond?
Your Honor, given that the second one was not a DUI-related possession, it would ask that you revoke and double.
Double it?
Double or set a higher.
All right, yes. And that would be what the court's conclusion is going to be. I still will hear if you have a challenge to the probable cause for the DUI. You may make that at this time.
Yes, Your Honor. In reviewing the court file, I'd ask the court to take judicial notice of the court file 23 CT 2727. Contained within that court file is the DUI packet, as the court might be familiar with.
Yes.
And I provided copies to the state that I printed out from the docket before I left my office of the blow and the BTO report that the court might be familiar with. May I approach?
I have those documents.
I'll just note for the record that it was a 000 blow, and obviously it's not alcohol related. And they only called it a refusal because he could not provide a urine sample, but he was cooperating, so they have no evidence that it was any urine back. So I would challenge probable cause at this time.
For the DUI, because the refusal is not what he was charged with. He was only charged with the DUI.
I agree with that. I would challenge the DUI, but because there's no blow and there's no urine.
And you're challenging probable cause?
Yes.
Yes, State, you may respond.
Ron, respectfully, neither of those things go to probable cause for DUI. For a DUI, the defendant has to be operating a motor vehicle on the states and highways of Florida, which was not contested. However, it's also within the affidavit. And while in driving or in physical control of that vehicle, it was under the influence of an alcoholic beverage or a chemical substance or a controlled substance to which the extent of their normal faculties were impaired. It's littered with throughout the affidavit different ways that Mr. Soto's faculties were impaired. He was a sole occupant. Officer found and smelled what he believed to be cannabis all throughout the vehicle. And then doing his FSCs, he stepped off the line many times, didn't follow instructions. And State can put all that on record if necessary. However, it's littered throughout the affidavit, different ways in which his normal faculties were impaired. So this time State would argue that there is PC. State does not need a blow to even get beyond a reasonable doubt at trial. So PC is a much lower standard than beyond a reasonable doubt.
The challenge for probable cause is denied. Probable cause is determined. Bond is set at $500. The court revokes the bond in the possession of cocaine case. Specifically, the court also noted that this was a triple zero blow, and that the officer was concerned about the possibility of this being a DUI related to the use of illegal narcotics. And the charge in the out on bond case is illegal narcotics. So I am revoking that bond. And it was $1,000 and the state is recommending me double it. So I'm just gonna reset that bond to $2,000 at this time.
Okay, so bond on the felony is 2,000 and bond.
It's now 2,000. It was 1,000, but I revoked it.
Okay.
Now I am ordering something else with him, if I can, but I need to check so with the scrim, do they do drug monitoring or just alcohol?
I'm not too sure, Your Honor, it may just be alcohol.
Okay. Well, I still can order something else. I am ordering that the defendant consume and possess no illegal narcotics or no illegal drugs, or no prescription medication for narcotics unless he has a prescription by a doctor. And I am ordering him to submit to random drug testing through pretrial release as a condition of bond on the DUI case, random drug testing. I am ordering this to be at his own expense.
And there may be a VOP coming because he's also on probation also for a drug case.
Well, there's a lot of moving parts.
Judge, did you order scram?
I chose not to order scrim. I am ordering it be done through the random drug testing be done through pretrial release.
Okay, understood.
Because I know they can monitor it, and I am not 100% sure about scrim monitoring drug versus, I know they monitor alcohol, but I have to research whether they monitor drug use.
Yes, Your Honor.
I am satisfied as long as he is getting monitored through pretrial release.
Thank you, Judge.
All right, thank you both.
Judge, do you want to address, do you want to just leave? He has arraignment set for tomorrow with Judge Navarro on the felony. You just want to leave that for Judge Navarro for tomorrow?
Yes.
Okay.
Absolutely. Yes, he'll still go before Judge Navarro for any arraignment that's previously set. I do have one arraignment this afternoon, but that's not his. All my arraignments are misdemeanors.
I have nothing further before the court. May be excused.
You're excused, yes.
Thank you. Good to see you, Judge.
Good to see you. All right. The next case, Ryan Diaz Robles. Mr. Diaz Robles, I do find probable cause for your charge, Jez, of fleeing and eluding a police officer and a moving traffic violation for racing a motor vehicle. And counsel, You may state your presence, counsel.
My name is Deveron Brown, appearing on behalf of Mr. Ryan Robles.
Okay. Mr. Brown, Mr. Diaz Robles qualifies for pretrial release, and my plan was to order him to be released on the pretrial release program. He also has a resisting an officer without violence, and I would also release him on the pretrial release program for that charge as well. But of course, I will hear what you have to say regarding his cases.
Well, if you're going to release him, I have very little to say.
I am releasing him on a pretrial release, unless there's an update and he doesn't qualify.
No, he does, Your Honor.
So he qualifies for pretrial release. Sir, I am ordering you to be released on pretrial release. I am, state, do you have any conditions? Maybe no contact with the co-defendants, or there's a lot of people.
Yes, Your Honor, so
involved
ask for
in
no
this.
contact with the co-defendants and no,
Sir, I am ordering no contact with the co-defendants. I don't know if any of the co-defendants or the co-defendant that was actually charged, or I don't know if they charged anybody other than that one other guy. I don't know if that's your brother.
No, I actually don't know him.
Okay, well, you guys have different last names, so I'm ordering no contact with him. I also am ordering no return to the location where this incident started out at. I mean, I guess it went on and on and on all over Orlando, but it started out at Lancaster and, where was the intersection? Lancaster and,
Lancaster and Fairway Woods Boulevard?
yes, Fairway Woods and Lancaster, where it started out at. I don't think I could order you not to return to all the locations where you were followed.
I think it would be impossible for me to get anywhere if I was.
Yeah, you wouldn't be able to go anywhere in the whole southeast Orlando.
That's correct.
I wouldn't be able to even get to work.
But you're not to go back to Lancaster and Fairway Woods,
Like where we were at,
where it started out, where the officer says it started out at.
train station, or the bus station, train station.
Yeah, it's a train station. Don't go back there. If you get caught over there, then you're violating my order. Otherwise, you're not. Counsel, thank you.
Can I be excused?
Yes, you're excused. Both, no, not on the resisting, just on the moving violations. Amy Millikin, this is the one arraignment that I have. And have we heard back from Rochelle? Oh, we haven't. What did she said? I'll look at it and say, oh, no, I look at it right now. Thank her for the response and tell her I'm gonna set the $100,000 bond, or you can just say thank you. Ms. Millikin, you're here for an arraignment on a charge of resisting an officer without violence. The public defender has handed me a plea form. Ms. Public Defender, she entering a plea of guilty or no contest?
Of no contest, Your Honor. The offer was an adjudication of guilt, credit time served, and court costs.
All right, I'm showing 26 days credit for time served. Ma'am,
She may be on probation, I'm just double checking.
you may be on probation, okay.
She's here for a bit.
Is that a situation where maybe we need to find out what's going on with the probation before accepting a plea?
She's actually here on the VOP.
All right, so she has another case?
She's here on
All right.
another case.
Do you all want to research that VOP first before she pleads out on this?
She's here on it. She's having no bond status.
Yes.
All right, so
I just asked for a court date, Your Honor. I didn't see the.
all right, this case will be set for a pretrial conference in Division 82.
It'll be May 18th at 8:30 in courtroom 9B.
Thank you. We can bring Mr. Justin Watts back on in here. I have an update for him. Justin. Mr. Justin Watts, in your case, I have had communications with our fugitive unit. I have asked them to contact Hudspeth County Sheriff's Office, and they did, and they advised that the bond is $100,000, and it was issued by their courts. They were, and I did ask the fugitive unit what would happen if I imposed the $100,000 bond, and would that preclude them from continuing with their process? But they're still going to continue with their process to extradite you. And they were actually told that Hudspeth County intends to extradite you. But Hudspeth County was also not objecting to me entering the $100,000 bond. So I'm going ahead and do that. Well, I already did, and it will remain as a bond so that you can start the process of attempting to bond out. Now, you do have the other issue that I told you about. I don't know if you can bond out from Orange County, and you may have to coordinate that bond in Hudspeth County, and I don't know if you can bond out from there either because of the fugitive aspect of your case. So, but after what you told me today, I mean, I know you want the bond to be imposed, and I know you want to try to bond out. I hope it's not against you that you want to keep the bond instead of me doing the no bond and putting you on a regular rotation with Judge Calderon, because now you got to come see me. And I don't know if you're going to be able to bond out. I don't know what's going to happen. But I'm going to set you for a return date in Division 85 for May the 4th, 2023 at 9 o'clock. And if you have already bonded out, then you've already bonded out. You still need to come see me. Guess what happens if you don't show up? I set a bond for failure to appear. Guess what the bond amount is that I would set? No bond.
No bond.
That's what I would do. But that's what you're choosing to do, okay? And I will keep setting these returns until I determine that you have made it back to Hudspeth, Texas, and that you are continuing to follow up on the case there. It could be detrimental to you for me to do that. It might almost be better for you to just let it go through the normal process. But given the normal processes, I'm going to set no bond. And I know I heard you earlier today that you want the bond so you can try to bond out. Either way, you're going to get return dates, whether it's me or Judge Calderon. You're going to just keep getting return dates to come back if you bond out. If they don't, if you don't return on a bond, and then the extradition process is going to continue. So let's say you're not able to bond out. You try, but you're not able to come up with the money to bond out, or no bondsman will bond you out because of you being a fugitive from justice. The allegation of being a fugitive from justice is against you, and that will be the reason why maybe you might find it difficult getting a bond. We are continuing with the extradition process. that means that Texas can come and get you. They may come get you or they may not. If they come get you, they usually notify our fugitive warrant of a date, and it's usually within 30 days that they come and pick you up. If they don't pick you up in 30 days, then our fugitive warrant brings me an order and I make a decision whether or not I'm gonna go ahead and release, just set the, release you. But you are having a bond of $100,000 versus being released with, just being released is what, I want to be sure I explain this how you understand it. And I think I just botched that up, so let's just go into the future here. Okay, let's talk about the future. Assuming that you cannot bond out, and assuming that at some point there is, we find out that Texas isn't coming to get you, I'm leaving the bond at $100,000 because that's the bond that I've been given. Do you understand?
Yes.
Assuming that you go before Judge Calderon and he goes through his regular, normal process and they don't come and get you, he may just release you. Do you understand the difference?
Yes, I do.
$100,000 versus just release him. I will not just release you unless a judge from Texas informs me that they have reduced that bond from $100,000 to ROR. I will not. And I just don't know whether or not setting the Texas bond is detrimental to you or not. Okay? Now, having said all that, do you want me to keep the bond at $100,000 and set you for the return date on May 4th, 2023 in Division 85 where you will come see me? Or do you want me to keep it at no bond and let you go through our normal process and go through to see Judge Calderon, in which case you probably would see Judge Calderon next week on Wednesday. You'll see me on Thursday.
Are there no open times for me to see Judge Calderon this week at all?
I don't set his calendar, but he did tell me that he usually does them on Wednesday.
Okay, and would it be too late to maybe get added to his calendar for this Wednesday?
I don't set his calendar. I only set mine. And I am telling you right now that the first time I can see you would be next week on Thursday because I have pre-trials on Monday and trials Monday, Tuesday, Wednesday, and Thursday, but Thursday's my lighter day. And sir, I'm here at the jail all this week. So if Judge Calderon could see you this week, he's not going to because I've already put you on my docket. And I cannot tell you that he cannot see you this week. Maybe he can. I did not discuss that with him when me and him were talking about it.
Okay, and any way to pull the future date closer?
For me or for Judge Calderon?
You.
No, I just told you that.
Okay, so the 4th is the
That's the date.
Okay.
Mm-hmm.
All right, so
one way you get a bond, but you get a known date of May 4th. The other way, you get no bond, but you don't know when you go back to court, but you do know it would be on a Wednesday. And it could be this Wednesday, but it also might be next Wednesday with Judge Calderon. Either way is correct. There's no wrong way to do it of these two ways. It's just that one way is the more, Judge Calderon's an expert in doing these, at least. He may not want me calling him an expert, but I'm calling him an expert because he handles all of these. But at the same time, you actually have a bond, and most fugitives don't. And it may be that he will still see you. I could ask him. I don't want you stuck in jail when you could potentially bond out. I understand that. That's the only reason why I'll leave the bond set at $100,000. Because, sir, that would just really, it would bother me for you to be in jail with the potential, knowing that you could bond out, but you can't because I left it at no bond. So why don't I just leave it at the $100,000 because it's going to bother me. And we see what happens with it. And, you know, it's not my intention to have you languishing in jail forever. But I also know that I don't have the authority to change a bond from Texas to release you. And I don't know what Judge Calderon's process normally is.
Okay. And just a last question. Is there a possibility that I might be able to have you keep the bond at $100,000 and we still set an appointment even if I'm released for me to meet with Calderon?
When you say set an appointment, what do you mean?
Set an appointment or a court date so that way I can get a little bit better understanding of.
With me?
With Calderon, since he.
I can ask him.
Okay.
I could ask him. Right now, how me and him discussed it earlier today is that the normal process is it goes to him, but they are always no bond. And we just haven't seen this. You're a new, novel situation to me. And I just don't want you sitting in jail knowing that I have a bond here on you. And he did not say with certainty to set it in front of him. He said whoever sets the bond is who gets the case. So I'm setting the bond because otherwise I'd be giving you no bond, knowing that the judge in Texas gave you a $100,000 bond. So it's just really different. I don't like people staying in jail if they can potentially get out. I don't think anyone likes that. I don't think I'm the only person. I think the jail people want you to bond out if you can bond out, because they have people who cannot bond out who really should be in jail. If you have a bond, then I want you to be able to post it. When we contacted Texas, they did not give me any additional conditions of release, so I'm not ordering any additional conditions of release from Texas. However, I am ordering you to appear on May 4th, 2023 in front of me in Orange County at 9:00 a.m. if you're out of jail, or if you're in jail, we're gonna bring you over from the jail and I'll see you then, okay? And I'll leave the bond at $100,000 and we hope that for the best. I cannot give you anything better than that. That's it. That's the best you're gonna get today, okay?
Okay, thank you, ma'am.
All right, thank you. You're excused. Yes, it's a status. It's actually a return hearing. It's a return hearing. Yes. Oh, I think this is your paper. And these are my papers. Now I have to remember to have what I need to put it on my docket. Dwight Sabalero.
Yes, ma'am.
All right, Mr. Sabalero, the court finds probable cause in your case for disorderly intoxication. He does not qualify for the public defender's office. I had no intention to appoint them, but if you want to represent him as a friend to the court on this plea, I will allow that.
Okay, yes, Your Honor.
The state did convey an offer of a withhold and credit for 2 days or 1 day.
All right.
He would like to accept an interplea of no contest.
As a friend to the court?
Yes, Your Honor.
All right. Mr. Sabalero, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read this plea form before you signed it, sir?
Yes, I did, Your Honor.
All right, sir, are you under the influence of any alcohol, medication, or drugs this afternoon?
I'm sorry, could you repeat?
Are you under the influence of alcohol, drugs, or medication?
No, ma'am.
Do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, I understand.
All right, sir, I reviewed your file. There's a sufficient factual basis. You're alert, you're intelligent. In your case, I will withhold adjudication of guilt. How much time served was that?
1 day.
Order 1 day in jail. You will be given credit for the 1 day you have already served. I am ordering mandatory court costs in this case to be paid within 365 days of release. I also am ordering your release as to this case. No public defender. Do you have any questions?
I do not, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You may exit for your paperwork. Thank you so much.
Thank you, ma'am.
Sandra Lavinia Donacimento, previously bonded per the jail staff. Eric Scott Colby, bonded per jail staff. Christina Martinez. Ms. Martinez is coming in. Ms. Martinez, in your case, the court finds probable cause for petty theft.
Can I say something, ma'am? No, I have,
I'm sorry, hold on a minute, ma'am, just one moment. And I am setting, the bond is staying set at $500 for that charge. State that you want me to order no return?
Yes, Judge, as I believe they were true victims' porches.
Okay.
that's stage 4 cancer, ma'am.
Ma'am, hold on a minute. I also am ordering that you not return to the location where this incident occurred and have no contact with the victims. Now, ma'am, you may go ahead.
Okay, ma'am, I would like R&R. I really don't have nobody to help me. I have stage 4 cancer. I'm supposed to be at Advent Health every day to get my chemo. And I know.
What says the state
Your Honor,
to a request for ROR?
state would object. She has 4 prior failures to appear, the last being in 2022, and her.
Ma'am, I'm gonna not run. I can't even, I had to learn how to walk.
One moment, ma'am.
Almost all of her criminal history are also theft-related offenses, so state would object to an ROR.
Ma'am, at this time, the state is objecting to a release on recognizance, and they have given me a reason why. And the reason why is because of previous failure to appears,
I understand.
along with,
Now,
there's another reason, 2 reasons. The second reason is that the cases that are from the past are also theft-related. I cannot ignore what the state has given me.
I understand, but
Ma'am, I hear you. I hear you, but I want you to let me finish. The last thing I will say is, you haven't provided me any proof. Anyone can say that they are under a doctor's care.
I take.
Last thing I'm going to say, ma'am, last thing. I want you to attempt to get any documentation that you can to the public defender. The public defender can then,
Ma'am, thank you. Have a blessed day.
wait a minute. Listen to yourself, ma'am.
Ma'am, I understand. I understand.
Listen to yourself.
Do is-
I am not, ma'am, listen to me. I am not going back and forth with you, but however, I am not going to allow someone who I took the time out to listen to you,
I'm sorry.
then disregard my comments back to you. That is not the way it works.
Apologize.
And you know, ma'am, I am not sitting here, not listening to you. I am really feeling badly if you actually do have cancer, really feeling badly about your circumstances. But I also have a state attorney sitting right over there who has provided me with details about prior criminal history and details about prior failure to appears, and I cannot ignore valid information from my prosecutor. So, ma'am, just think about your actions and your words and how you want everything how you want it.
Yes,
And maybe I'm about to tell you something that can help you.
ma'am.
If you can bond out, that is awesome. But for some reason, you cannot bond out. You try to get the information that is necessary to that public defender so they can show it to a judge, confirming your diagnosis. And maybe the judge looks at that as a valid reason why the judge would go ahead on and allow an ROR if for any reason you are unable to bond out. And that is the last thing I need to say. You are excused.
Thank you, ma'am.
Andre Solomon.
And I did have a PC challenge, Your Honor.
All right, the court will hear your PC challenge at this time.
Defense would argue no PC as to count 1. Based on the 4 corners of the affidavit, there's no indication that he committed the offense with someone, which is a requirement of the Florida statute 800.02.
Okay, what says the state?
Your Honor, defense did provide case law regarding with and another person, and the facts alleged within the affidavit do not comply with another person.
Mhm.
So at this time, state has no objection to an ROR on one.
Okay.
There's no other charge at this time that I can find that more clearly clicks with the,
The facts of the case.
yes. So state would ask for an ROR on one and a reasonable bond on two.
So the court is going to grant the, wait a minute, you're asking for ROR and a finding of no PC?
Yes. On
Okay, yes, the court's going to grant the defense motion, and the state notes that the state has no objection to it. The court does not find probable cause for committing a sexual offense pursuant to the statute that was charged. So I ROR you as to that charge. The court does find probable cause for trespassing, and bond will stay at $500. I am ordering you to not return to the location where this incident occurred. Thank you.
State would also ask for no contact with.
I am ordering no contact with the victims in this case. Yes. Juan Vega Perez. Mr. Vega Perez.
And there is an offer, Your Honor.
All right, Mr. Vega Perez is making his way to the podium. The court finds probable cause for trespass on property after a warning. Defense will inform me of the offer.
The offer is an adjudication of guilt, credit, time served, no return to 8049 East Colonial Drive. And Mr. Vega Perez would like to accept and is a plea of no contest.
Okay, what's the time served on Vega Perez?
2 days, and just for the record, it's a Wawa.
Okay. Mr. Vega Perez, is this your signature here at the bottom of this plea form?
Yes,
Did you read the plea form?
yes,
Are you under the influence of any alcohol, drugs, or medicine at this time?
no, ma'am.
Did you say no,
Am I in the influence?
or did you say yes?
You gotta say no. Right here. You're saying it too low.
Are you under the influence of any medicine, sir?
No, ma'am.
What about alcohol?
No, ma'am.
What about drugs?
No, ma'am.
Do you understand that a conviction on this case will subject you to being deported if you're not a United States citizen?
Yes, ma'am.
I have reviewed your file. There is a sufficient factual basis to accept your plea, and you are alert and intelligent. I will adjudicate you guilty, order 2 days in jail with credit for 2 days, and order you to not return to the Wawa located at 8049 East Colonial Drive. I am ordering all mandatory court costs and giving you 365 days to pay through the clerk of courts. Sir, do you have any questions?
No, ma'am.
Now, I am ordering you to be released as to this charge. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. You may exit.
Thank you, ma'am.
Daniel Negron. Are you Daniel Negron? Yes, sir. I find probable cause for the charge of disorderly conduct, and was there an offer in this case?
Yes, state did convey an offer of an adjudication and credit for 1 day on behalf of the city.
And you would like to accept and is a plea of no contest, Your Honor.
Mr. Negron, is this your signature here at the bottom of this plea form?
Yes, Your Honor.
And did you read this document in its entirety before you signed it?
Yes.
Are you under the influence of any alcohol or drugs or medicine?
No.
Do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Understood.
You understand that?
Yes.
All right, sir, there's a sufficient factual basis to accept your plea. You are alert, you're intelligent, you're adjudicated guilty. You're ordered to serve 1 day in jail with credit for 1 day time served. I am ordering your release as to this charge. I'm further ordering you to pay mandatory court costs. You have 365 days to pay all court costs with the clerk of courts. You have the right to appeal the sentence. If you wish to appeal, then you must do so in writing within 30 days of today's date. Any questions?
No, ma'am.
All right, you may exit for your paperwork. Thank you, sir. Carlos Ambrosio Guzman.
Bonded, Your Honor.
All right, bonded per the jail staff. Juan Osias Canal de Leon.
Bonded, Your Honor.
Bonded per the jail staff. Baldemiro and Antonio Baldemiro Roblero Avila.
Bonded, Your Honor.
Bonded per jail staff. Brandy Amos. In your case, the court finds probable cause for burglary of a dwelling with an assault or a battery, and bond is going to stay at no bond. You're ordered to have no contact with the victims, not return to the location, not return to the address. They were roommates, so I'm assuming that,
I stay at their address.
I know that, but I'm gonna talk to the state. They were roommates, so I'm assuming that you want me to have her not return to the address, not just not return to the room where it happened.
Yes, Your Honor. And when they do a farther hearing downtown, they'd probably also further nail down some of the conditions,
Okay.
such as like a one-time return, because I'm assuming.
I will allow a one-time return in the presence of law enforcement to recover personal belongings. But ma'am, specifically, you are to not return to the address where this incident occurred. I am appointing the lawyer from the public defender to represent you, and they will have to bring any further issues to the assigned division judge. Thank you. Do you want me to order possession of no weapons or firearms?
Yes.
It was some kind of tube that was used, but
I believe it was a pipe of some.
piping, yeah. I'm gonna order possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, ma'am. Antoine Andrews.
Andrews refused his appearance, Your Honor.
Defense is waiving his appearance. The court does find probable cause on both counts. Count 1, bond stays at $100,000. Count 2, bond stays at $150. State, he has an out on bond case that involves drugs, and I'm asking you what the state's position is on that. I'm not taking any action on the burglary, out on bond burglary. The ROR for the burglary stands, but he also has a possession of firearm and possession of controlled substance charge from 2022 CF 985980. What says the state?
Yes, Your Honor, that one has been filed as of January of this year.
Okay.
The state would ask that you revoke.
Okay, I am going to revoke the ROR. Do you want me to set a bond?
State would ask that it be a no bond, given that this case is an F1 trafficking, and that case is also.
Okay, I will order no bond on both count 1 and count 2. Raymond Brinson, bonded per jail staff. James Butner.
He refused his appearance, Your Honor.
Defense will waive.
The court finds probable cause for count 1, 2, and 3. Bond stays at $1,000 on count 1, $150 on count 2, and $100 on count 3. Defendant is ordered to not return to the location where this incident occurred. Daniel Campos.
He's on behavior status, Your Honor.
Defense will waive.
Defense is waiving. The court finds probable cause. Oh, thank you. As to count 1, count 2, and count 3, the court orders a bond of $4,500 on count 1, $500 on count 2, $1,000 on count 3. And defendant has he has an out on bond case. Is that the same as this one? 11311580. Where he was on pretrial release. The court is revoking pretrial release and state. I'm gonna set no bond. No bond. Wait a minute. Revoking the bond and revoking pretrial release. He had a bond, an MPTR, setting no bond. That was Daniel Campos, right here. Justo Annabelle Estras. All right.
Defense will waive.
Defense is waiving his presence. Court finds probable cause for count 1 through count 5. Bond stays at 5,000 on count 1, 1,000 on count 2, 1,000 on count 3. Wait a minute, count 1, the court had a question, sorry. That charge says possession of a controlled substance, juvenile detention facility. What is this about? He's 48 years old.
I believe it was an error, Your Honor. I believe it was possibly just supposed to be possession of a controlled substance. Because even if it was just an error, he didn't, allegedly within the affidavit, there was nothing regarding him bringing anything into the BRC even.
Right.
I believe that's largely an error, so state would ask for an ROR on 1.
So the court will grant that and release on recognizance as to count 1. Bond stays at 1,000 on count 2, 1,000 on count 3, 4,000 on count 4, and 5,000 on count 5. The court is specifically not finding probable cause as to count 1. The court is ordering that the defendant consume and possess no firearms or weapons and surrender any firearms or weapons to law enforcement within 24 hours of release. The court will revoke the bond on the out on bond case unless the state hasn't filed charges on that yet, being the case number seems to be from December or October of 2022. The state likely has filed charges. I had planned on revoking the bond and doubling it.
State did file an information for the carrying a firearm, possession of cocaine, and destroying evidence.
All right, the court is ordering a revocation of the bond on count 1, count 2, and count 3. What was the breakdown of the bonds on count 1, count 2, and count 3 in that case?
To my understanding, originally the carrying a concealed was 500.
All right, bond is set at 1,000 on that count.
Cocaine was not originally in the officer's arrest. Cocaine usually comes in at 1,000.
All right, I'll set bond at 2,000 on that.
And then the destroying evidence originally, I believe, was 2,500.
And bond is set at, what did you say? Yes. Count 1, 1,000. Count 2, 2,000. Count 3, 5,000. It should total 8,000. Does that total 8,000? Okay, then that's what my intentions are. Thank you. Is the state asking for any conditions?
No, Judge.
All right. Matthew Brian Fisher.
Yes, ma'am.
Mr. Fisher, you were picked up on a capias. So now, I have the paperwork from the judge appears to indicate mental health pretrial release, but what's written on my paperwork for initial appearances is no bond. So I have a contradiction.
Your Honor, yes, we received an email from our mental health specialist staff, Helen Burns. He did not qualify for mental health PTI. He didn't meet the criteria. So we need to ask if you can delete the mental health PTI and give him a bond.
I see.
He didn't meet the qualifications.
He does not qualify for the mental health pretrial release at all.
No.
All right. So the court who was requesting mental health pretrial release perhaps was not aware that he would not qualify, and you're asking for no bond. What says this, everybody, the state, defense?
Your Honor, it originally came in at no bond because it was a PC capias. However, he is entitled to a bond, so state would just ask that you set a reasonable bond and the conditions that come along with a battery, no contact, no return, no weapons. And it appears most of Mr. Fisher's history is out of state.
Okay. Is this based on a violation of pretrial release, though? Or is it just, it's the, it's a capias? Yes, I'll grant that. The court will set a bond of $1,500, noting that the defendant does not qualify for mental health pretrial release. The defendant is ordered to have no contact with the victim.
State would also ask for no weapons, Your Honor.
The court orders that the defendant possess no firearms or no weapons and surrender any firearms or weapons to law enforcement within 24 hours of release. Thank you. Omar Gordon. Mr. Gordon, the court finds probable cause for fleeing, eluding a police officer. And in your case, you do qualify for pretrial release, so I am ordering pretrial release. Condition of pretrial release is to have no contact with the co-defendant and do not return to the location of State, where did this start at? Was it North Hiawassee Road and Dorset Road?
Yes, Your Honor, I believe so.
Do not return, you do not live in the area of North Hiawassee or Dorset Road, do you?
I do not.
Now, I'm ordering you to not return to that area as a condition of your release. All right, thank you. Cedric Harrell. In your case, the court finds probable cause for possession of 3,4-methylene methamphetamine MDMA ecstasy, and bond will stay at $1,000. Thank you, sir. Ethan Harris. Mr. Harris, you were picked up for violation of pretrial release on 2 counts, and bond will stay at no bond on both counts. Thank you, sir. Dandrick Hooks.
Defense will waive.
All right, as to Mr. Hooks, defense is waiving his appearance. I know find probable cause for count 1, possession of methamphetamine MDMA ecstasy, bond stays at $1,000, and count 2, resisting an officer, bond stays at $500. What says the state as to his out on bond case, 2023 CF 631AO? Has that case even been filed on yet?
It has not. State would request no action.
All right, no action as to that case. St. John, Marcella St. John.
My apologies, Your Honor, that defendant is not on our docket.
Marcella St. John is not on your docket.
You have a booking number?
Oh, yes.
It'll be 2301-0373.
Bonded.
Bonded per the jail staff. And Taisha Moultrie.
Defense will waive.
Defense waives her appearance. Bond, the court finds probable cause for possession of 3,4-methamphetamine MDMA ecstasy. Bond stays at $1,000. Alexis Negron Rodriguez.
Refuse his appearance.
Your Honor, defense will waive. However, we had a PC challenge as to the sale and delivery of fentanyl. I believe it should be with intent to sell. There was no sell or delivery that was mentioned in the affidavit.
What says the state?
Your Honor, state agrees. We previously spoke about this.
Any objection to me finding probable cause of possession with intent to sell?
No, Your Honor.
And setting an appropriate bond defense?
No, Your Honor, no objection.
All right, court finds probable cause for count 1, trafficking in dangerous drugs, fentanyl or fentanyl analogs 4, and bond stays at $500,000. Count 2, possession of fentanyl with intent to sell. The court will set a bond of $7,500. Count 3, possession of fentanyl, bond stays at 1,000. Count 4, count 5, count 6, count 7, and count 8, possession of possession of ammunition by a convicted felon. The court will set a bond of $150 on each individual count, each count. The court is ordering the defendant possess no firearms or no weapons and surrender any firearms or weapons to law enforcement as a condition of release.
And Your Honor, there is one more count. There's a count 9.
What? I didn't see that one. And I did look, because I am known for missing the second page, so I looked and still didn't see it. This is the count involving destroying evidence, renumbered. Okay, I gotta read that. Let me see what that is about. The possession with intent to sell would be count 2.
And I do have a new statute for you, Madam Clerk. 893.13, sub 1, sub A, as an apple, dash 162, and that's possession of fentanyl with intent to sell or deliver.
All right, destruction of evidence, the court finds probable cause, and I'll reduce that from $500 to $100. There you go. Bob Peterson. Are you Bob Peterson? The court finds probable cause for possession of cocaine. Bond will stay at $1,000 in that case. Thank you. Brian Eugene Pompey. Mr. Pompey? Okay, not here yet. Mr. Pompey, the court finds probable cause for possession of 3,4-methylene MDMA ecstasy. Bond stays at $1,000, and possession of cocaine, the court is reducing the bond to $500. Thank you, sir. Keith Powell, the court finds probable cause for possession of cocaine. Bond stays at $1,000. Robin Renee Richardson. Okay.
Okay. And, Your Honor, I did have a PC challenge.
As to the possession of cannabis?
Yes, Your Honor.
Okay.
State has no objection, Your Honor.
All right. Ms. Robin Renee Richardson, the court finds probable cause on count 1, possession of cocaine. Bond stays at $1,500. I do not find probable cause for possession of cannabis less than 20 grams, and I'm going to order you to be released on your recognizance as to that count. I do find probable cause for possession of paraphernalia, and I will order the bond stay at $100 for that count. You do have a case you're out on bond on, battery, and I will take no action on that case. Thank you, Ms. Robin Renee Peterson. Mr. Justin Ruiz. The court finds probable cause for carrying a concealed firearm. Bond will stay at $5,000. And possession of cannabis less than 20 grams, bond stays at $1,000. You do not qualify for the public defender due to your income, so I am not appointing the public defender to represent you. Thank you. You can, sir, you are entitled to a lawyer, so you need to hire your own attorney. You can also ask the judge at your next court hearing to reconsider appointing the public defender based on income. John Elias Sanchez, in your case, you were picked up on a warrant for A charge of possession of cannabis with intent to sell or deliver in bond will stay at $3,500. State, I don't know if you were asking me to take any action on this out on bond case since this was a pickup on a warrant? Or, I don't know which one happened first.
I'm not entirely sure, Your Honor.
Okay, well,
The out on bond has been filed. The alleged,
it was filed, okay.
it's a trafficking and a possession, the alleged date of incident on the out on
Well,
bond.
I won't take any action on it. Court will take no action on the out on bond matter. Trophy Lee Walker. In your case, the court finds probable cause for count 1, possession of cannabis with intent to sell or deliver, bond stays at $1,000. Count 2, possession of cannabis greater than 20 grams, bond stays at $150, sorry. And count 3, possession of paraphernalia, bond stays at $100. Thank you. Xavier Walker. The court finds probable cause for possession of a short barrel firearm or machine gun or rifle, and he qualifies for pretrial release. You also have count 2, openly carrying of weapons or firearms. You qualify for pretrial release. I am going to order you to participate in a pretrial release program, but I'm ordering you possess no weapons, no firearms, no ammunition, and that you surrender any weapons or firearms or ammunition to law enforcement within 24 hours of your release. Thank you. Toby Wells. As to Toby Wells' counsel, since she refused, are you waiving?
I will waive.
Court finds probable cause for grand theft. Third-degree bond stays at $1,000. The court's ordering no return, no contact. Jeannie Wilson.
She also refused, Your Honor.
And are you waiving? Court finds probable cause for grand theft, third degree. Bond stays at $500, no return, no contact. Daciana Garrely Woodley. Daciana Woodley. Come to the podium. Ms. Woodley, the court, you were picked up on a capias for grand theft and dealing in stolen property. Bond will stay at no bond on both counts.
She's in, no.
I'm sorry, someone making a
Your
comment.
Honor, I believe she's entitled to a bond.
It's a capias. So since it was a capias for failure to appear in front of a judge,
I thought it was
the judge said no bond, and I'm gonna leave it at no bond at this time. However, she can, she can set a motion hearing.
yes, Your Honor, I thought it was a new.
All right. Latina Young.
She refused her appearance, Your Honor.
All right. Why don't I have the Woodley case? Oh, that was the Woodley case. All right, I already did that. Latina Young, she refused. Is there any?
I will waive, Your Honor.
Waiver. The court finds probable cause for petty theft. Bond stays at $500. Possession of cocaine. Bond is set to stay at $1,000. And possession of 3,4-methylene, methamphetamine, MDMA, ecstasy. The court is setting the bond or reducing it to $500.
She can get you before that judge. But that's it. They don't do anything today.
I don't have any other cases. Anything further, Madam Clerk? Court stands in recess.